Good day, everyone, especially to you, Dr. Jeah. My name is Jeah Rojo, and today we're going to talk about the chapter 13, which is the labor law. So, before anything else, and before we proceed, I'm going to provide to you first the topic outline and the objectives for this topic. So, first, we do have the introduction to labor law in tourism, which we will talk about the importance of labor law in the tourism industry, the common labor issues in tourism. And also, second, we do have the constitutional provisions on labor, which we are going to tackle the protection to labor, rights of workers, working conditions and wages, states' role in labor relations, and protecting of working women. Next is the classification of employees, wherein we're gonna tackle also the rights and obligations of each category and a case study on employment classification. So, also, we do have the employee benefits, privileges, and policies, which we will tackle about the minimum wage and collective bargaining, labor management council, maternity and paternity leaves, union rights, strikes and lockouts, and employment contract and service charges. And also, we're gonna talk about the additional benefits and considerations, which will tackle social security and employee well-being, retirement and health benefits, drug testing policies and mandatory coverages for SSS, PhilHealth, and Pag-ibig. And lastly, the termination of employment, which will tackle the just and authorized causes for termination and the due process requirements. So for our objectives, we are being expected that by the end of this chapter, the readers should be able to understand the significance of labor law in the tourism industry, to identify the constitutional provisions that protect labor rights, to differentiate between various classifications of employees and their entitlements, to recognize the rights and benefits available to employees under labor law, to comprehend the legal processes involved in employment termination, and lastly, to apply legal principles to real-life labor issues through case studies. So the tourism industry, with its intensive nature, is prone to many labor issues, and hence, labor law plays a vital role in the efficient operation of the various business enterprises related to tourism. So, for this chapter, it will deal with important provisions governing labor laws as well as the benefits, privileges, and policies affecting employees. So, first, we're going to talk about the constitutional provisions on labor. So the Philippine Constitution establishes the fundamental principles governing labor relations. So first is the protection to labor, which the Constitution mandates the state to provide full protection to all forms of labor, whether local or overseas, organized or unorganized. So this reflects a commitment to safeguarding the interests of worker in all circumstances. And next is the rights of workers, which it explicitly guarantees the rights of workers to self-organization, like forming unions, collective bargaining, like negotiating with employers, and engaging in peaceful, concerted activities, including the right to strike. So next is the working conditions and wages. The Constitution also ensures that workers' rights to security of tenure, which is a protection against unjust termination, humane conditions of work, and a living wage. So, a living wage is defined as one that is sufficient to support a worker and their family with dignity. Next is we do have the state's role, which the state is tasked with promoting shared responsibility between workers and employers, encouraging the use of voluntary means like conciliation to resolve disputes, and regulating the dynamics between labor and management. So, this regulatory role aims to balance the rights of workers with the rights of enterprises to reasonable returns, expansion, and growth. And lastly, the protection of working women, which recognizing the unique needs of women in the workforce, the Constitution mandates the state to protect working women by providing safe and healthful working conditions, considering their maternal functions, and offering facilities and opportunities to enhance their welfare. So next is we do have the classification of employees. So the Labor Code categorizes employees to establish their rights and obligations. So these are the different types of employees. So first is we do have the regular employees. So these are employees who perform tasks essential to the employer's business or have rendered at least 1 year of continuous or broken service. they are entitled also to security of tenure. Next is we do have the casual employees, which are hired for tasks incidental to the employer's business for a specific period. However, if a casual employee renders at least 1 year of service, they are considered already as regular employees. Next is we do have the seasonal employees, which works during specific seasons. Like our regular seasonal employees repeatedly called to work are considered regular employees with security of tenure. Next is we do have the project employees. These are employees hired for a specific project with employment tied to the project's duration. And we also do have the probationary employees, which are under trial for a maximum of 6 months to determine their suitability for regular employment. Employers must inform them of the standards for regularization. Also, we do have employees for a fixed term. These employees are hired for a specific period, valid if agreed upon voluntarily and without circumventing security of tenure laws. And also, we do have the overseas Filipino workers or OFWs, which are workers employed in a foreign country, governed by specific laws like the Migrant Workers and Overseas Filipino Act. Also, we do have the special workers, which in this category, it includes the apprentices, which are workers in training under an apprenticeship agreement, and also learners, which are trainees in semi-skilled occupations for a short period of time, and handicapped workers, which are disabled persons, are entitled to the same terms and conditions as able-bodied employees. So for that, I will also gonna provide a case study or an application of the law. So for the case, the Philippine Airlines Incorporated or PAL contracted the services of GC Services Enterprises to undertake specific projects accordingly. So GC Services recruited and hired carpenters, painters, and electricians and assigned them to different PAL shops, namely carpentry shop, electrical shop, technical center shop, and in-flight center shop, all under PAL's Construction and Corporate Services Department. So these hired workers had been employed for a period ranging from 1 year and 4 months to 11 years and 10 months. In addition, these workers were supervised, directed, and controlled by PAL's regular employees. So for that, what is the classification of the workers which were recruited and hired by the GC Services for PAL? So for legal opinion, the workers recruited and hired by GC Services are considered regular employees of PAL. It is evident that the workers were employed by PAL through GC Services Enterprises as painters, carpenters, welders, or electricians as its maintenance department. So these workers were performing work and activities which are directly related to the nature of the business of PAL. They had been employed for a period ranging from 1 year and 4 months to 11 years and 10 months. This continuous employment indicates that their jobs are directly necessary to the daily operation of PAL's business. So therefore, GC Services Enterprises is merely a labor-only contractor who acted as mere supplier of manpower for PAL at its maintenance department. And accordingly, the employees recruited by GC Services Enterprises are considered employees of PAL. Further, the employees having performed activities which are directly related to PAL's business are deemed regular employees of the latter pursuant to Article 280 of the Labor Code. And as regular employees, they must be accorded security of tenure in their employment. So benefits, privileges, and policies affecting employees. So under this is we do have minimum wage, which the regional, tripartite, and productivity board sets minimum wage rates, aiming to provide a decent standard of living. And next is we do have the collective bargaining, which this process involves negotiations between employers and unions to create a collective bargaining agreement, or CBA, covering aspects like wages, hours, and working conditions. We do have also the labor management councils, which in these councils provide a platform for communication and resolving issues between management and employees, fostering a harmonious relationship. Next is the maternity and paternity leaves, which female employees are entitled to maternity leave benefits, while married male employees receive paternity leave, ensuring support for new parents. Next is we do have the union rights, strikes, and lockouts, which workers have the right to form unions and engage in strikes as a last resort in labor disputes, while employers may implement lockouts under specific conditions. Also, we do have service charges, which establishments like hotels and restaurants that collect service charges must distribute a specified portion to their employees. And lastly is the employment contracts, which these contracts outline the terms and conditions of employment, and while parties have freedom to contract, these contracts must adhere to labor laws and public policy. So next is we do have the additional benefits and considerations with Social Security and employee well-being. So for death benefits, Social Security laws provide financial assistance to the beneficiaries of deceased employees. For health benefits, employees are entitled to health benefits for sickness, injury, and hospitalization. For drug testing, employers may implement drug testing policies to maintain a safe workplace following legal guidelines. And for retirement, labor laws mandate retirement benefits for employees who reach retirement age. And uniform policies, which some tourism establishments require employees to wear uniforms, and uniform policies, which some tourism establishments require employees to wear uniforms and maintain a certain level of grooming, often as a condition of accreditation. And lastly is the mandatory coverage, which employees are generally required to be members of Social Security systems like SSS, PhilHealth, and Pag-ibig, which provide various benefits. So next is we do have the termination of employment, which are the legal grounds and procedures. So for just unauthorized causes, the Labor Code specifies the valid reasons for which an employer can terminate an employee. So this include just causes like misconduct or neglect of duty, and authorized causes such as redundancy or retrenchment. And for due process, employers must follow a specific procedure to ensure due process when terminating an employee. This typically involves providing written notice, conducting a hearing, and issuing a written termination notice. So in the ever-evolving landscape of tourism, labor laws serve as a guiding force to ensure that both workers and employers operate under fair and just conditions. So understanding employee classifications, rights, and benefits is essential in fostering a productive and harmonious work environment. By upholding legal protections and ethical labor practices, the tourism industry can continue to flourish while maintaining the dignity and welfare of its workforce. So that would be all for the chapter 13, which tackles the labor law, and I hope you have learned something. Thank you so much for listening and have a great day.